Hi, my name is Dennison, and I'm an associate at Mandelbaum Barrett in our Elder Law Department. And I'm joined today with Dan Stone, who's also an associate in the Elder Law Department. And today we're going to be talking a little bit about some of the most common mistakes that people run into when filing for guardianship in New Jersey. These are the things that we notice, the mistakes people make. Hopefully, by watching this video, you can avoid one of these pitfalls.
So obviously this is not exhaustive, but an issue that we run into often is the failure of noticing all parties, which is a critical requirement for any guardianship complaint. In addition to the alleged incapacitated person, or AIP, the next of kin of the AIP, meaning their parents, their siblings, their spouse, and their children, also require notice. This is critical because the input of these family members may be influential on the court's ultimate decision here.
And we recently litigated a case involving a failure to notice. It was, in this case, a sibling who was not noticed. In fact, the alleged incapacitated person's parent filed for guardianship, and the adult sibling of the alleged incapacitated person was never provided notice of the hearing, the guardianship itself. And so we represented the non-noticed sibling. Ultimately, we had the parent removed as the guardian. So it is critically important to identify those parties, those next of kin, like Dan mentioned, who are entitled to notice under the court rules. Why don't we talk a little bit about failing to provide adequate medical evidence?
Naturally, any guardianship complaint is going to require sufficient and reliable evidence of the AIP's lack of capacity. And in every guardianship complaint, there's a requirement that a physician or psychologist draft a certification demonstrating the AIP's inability to make decisions for themselves as a result of some medical or mental health issue. The state of New Jersey provides a short standard form, but the answers for that certification need to be sufficiently comprehensive to demonstrate the AIP's inability to make some form of decision making. It may not be all, it may be limited to certain areas of personal or financial decision making. But if it's vague or incomplete, it may cause the dismissal of the case altogether or delay the proceedings so that more documentation can be gathered.
Depending on the type of guardianship that's being filed, it may require 2 physician certifications or 1 physician certification in addition to an individualized education program at IEP if it's a DDD guardianship. And so it's important, 1, to identify the type of guardianship filing that you're making, and 2, to provide adequate medical evidence. It's one thing to have a doctor sign off on a physician certification. I think in cases where the case may become contested, having a vague certification is not going to do you any favors because it just leaves the door open to your adversary, your opponent in the guardianship, poking holes in the medical evidence that you're presenting.
And another important consideration is the AIP's own preferences. And often this falls by the wayside because it's difficult to ascertain. But if the AIP has previously established estate planning documents, those can be used to evidence the AIP's preferences. So an advance directive, like a living will or a power of attorney, may indicate what the AIP's preferences are as to their financial or personal affairs, in addition to a will if one exists. And of course, to the extent that an AIP is able to express their own preferences, they should be taken into consideration, but assuming that those preferences aren't clearly against their own best interest.
Yeah, that's right. It's often overlooked. Unfortunately, people presume that because someone is under a disability or even are maybe experiencing mild dementia of some sort, that they can't, for some reason, express their own wishes. New Jersey case law makes it clear that despite someone being under a disability, despite someone being forgetful, that their wishes, so long as those wishes are not patently absurd, should be considered and taken into consideration by the court even.
Before we even get to the conversation about guardianship, it's important to consider some less restrictive alternatives. These can take the form of what's called a conservatorship, which is tailored solely to financial affairs, but it requires the consent of, in this case, the AIP, and it can be freely revoked at any point. So in certain circumstances, that may not be appropriate. And then, of course, there are limited guardianships, which are guardianships as to limited areas of decision making. So, for instance, someone may not have the ability or capacity to make financial decisions while still retaining capacity to make personal decisions, like where they live, for instance.
And how often do you come across at least those limited guardianships, and sort of what sets the stage for a limited guardianship?
Well, I think that it's contingent upon the factual circumstances and the personal abilities of each person. I think that we run into it every case. I mean,
Yeah.
there's no one size fits all
Right.
for a guardianship.
It's really important that we, as the attorneys, try and preserve the alleged incapacitated person's rights. It's important to consider those less restrictive alternatives in every case. I think our last point, and it's probably one of the most overlooked considerations prior to filing for guardianship, is bonding. Can you talk a little bit about bonding?
Sure. So upon a person's appointment as guardian, the court may subject that new guardian to the payment of a bond, which acts as an insurance policy to protect the AIP's assets. Now, depending upon the AIP and their financial situation, that bond may be significant. And so this is, like you said, critical because it's overlooked and it's a significant financial obligation. In certain circumstances, the court waives it depending upon the size of the AIP's estate and the relationship between the guardian and the AIP. But that's not guaranteed and obviously is a significant factor here.
It is. We've run into some issues, not often, but sometimes, where a child is applying for guardianship over a parent. The child's financial circumstances, for whatever reason, aren't great. Mom or dad's financial circumstances are much better. They have sizable assets. The court imposes a bond, a surety bond, on them. And even though you've gotten through the guardianship and the court says to the child, you can serve as the guardian, I'm appointing you, but you need to get this bond, it makes things more difficult if the child does not have their own means of getting bonded, because there's a credit check that goes along with it. And it may become very difficult, even after getting through the guardianship. So it's an important consideration. You want to make sure that going into the guardianship, you're aware that that may be a factor in your appointment.
So this is a short primer on many common pitfalls that we run into in the midst of a guardianship proceeding. If you have questions, if you need help navigating that process, our team is here to help you. Please feel free to give us a call at any time.